Revision is dismissed. Revision is allowed.
Bail application. Bail application. If time permits, today as the last night. Police has called me tomorrow, man. And has already taken up.
Please, your lordship. Regarding item 33 and 34, lordship, the arrested bail, lordship, the case there has not arrived. Lordship. It's from Dispur police station. I have prayed on 19, lordship, if possible. 19, lordship, if possible.
Item?
Item 33 and 34, lordship. The BA, lordship.
Yeah, what do you want?
Can it be on 19, lordship? It's from Dispur police station, lordship.
The CD is not there.
CD not received.
Right, CD not received. List again on it. 19.
33 and 34. Much obliged, your lord. Much obliged.
At the item 40.
Item?
40.
647. CD not received. List again on.
There is interim.
Interim order passed earlier to continue.
812.
Please, your lordship. I'd like to push item 37, your lord.
Yes,
Is an interim, your lordship.
not received.
Is not.
Not received.
All right, same order.
And your lordship, item number 50, your lordship. Well, order, your lordship. The party that settled their matters, your lordship. They've taken up with your lordship.
52.
Yes, your lord. They've settled their matters to the mediation, your lordship. Forwarded by this honorable, your lordship.
We'll take it up as and when it comes.
Please, back to me number 40. From the updates, not really. You have received a case, but it's not up to date. You have to send back the case there in updation. So list the matter on 8/12. If possible on 5th.
Up to date CD is not available. Reset. Send back the CD. Up to date CD to be furnished by the next date fixed. List on.
5/12. There is interim.
Interim order passed.
Deeply.
May I please your lordship? Lordship, I beg to mention item number 56. Lordship, this matter has already been heard by Justice UK Nair. We have submitted our synopsis regarding disproportionate assets, and we have submitted our calculations regarding. Kindly be listed. Justice.
Item 56, it is submitted that the matter has been heard at length by another bench. Hence, is the matter before another bench, before the appropriate bench.
One.
27. Okay, after 2 weeks.
Lordship, I'm from the other side. 27th will be difficult because Mr. KL will be.
After
Yes. All right.
Much of it.
Wait. Right. It took completely. Council lot. Vegetable.
62.
It took. The CD is available. Vegetable lot.
All right.
My lord, I beg to mention item number 23 of today's list, my lord, daily list, my lord. My lord, 23, my lord.
Hmm.
My lord, the matter may be taken at 2 p.m., my lord.
At 2.
Yes, my lord.
All right.
Obliged, my lord.
Wait, please, your lordship. I beg to mention item number 45 of the date. Lordship is not available. And the date,
All right. They did not available.
I'm
List
on
again.
interim, your lord.
40?
45, your lord.
45. Didn't someone mention this?
46 and 47 are mentioned.
All right.
Lordship, the
Interim order passed earlier to
90 of the.
obliged. Lord.
next date of
Item number lordship 19, lord. I am on behalf of P. Hussain lordship. He is not well, lordship. So cannot come. So lord,
19.
any date after 1 week, because NBW is taken 1 week.
Oh, you'll have it as and when the roster permits. Give a date as soon as.
Obliged.
Right. I beg to mention item number 41. Perhaps CD
Not with.
All right.
interim is
List interim order.
All the 90.
if
RTC.
Not received.
Is not received. Just
Interim passed earlier to.
I beg to mention item 20 can be taken up after
20. Next week.
much of
Yes. Krishna has been arrested on 16th of October by lord. And all the
All right. CD.
got that. One. 25.
Don't know. How many matters can we list in a day?
Before.
Obliged. Lord.
May I please, your lord. Lordship, this is a regular bail application. This is a charge sheet matter, lordship. The lordship, court records. Otherwise, lordship, the FIR starts from page number 10. Bail application.
Yes.
Lordship,
And the TCL.
lordship, humbly pray at the low LC.
Okay. Charge sheet date, so TCR.
TCL will be called.
Submitted, the charge sheet has already been submitted, hence all can copy of TCR with PD.
I'm obliged, lordship.
Wait, please, your lord. Lordship, the petitioner type of the decision, the and lady, my lord, presently language jail hazard for 85 days. Instead of so registered as a murder of as a murder offense, but my lord, the is apparently a death of it's a natural death, and your lordship has already granted bail. The co-accused of this particular case, lordship will find that page number 30. being a pregnant lady and of the
Where is the earlier order?
my lord, page number 31. my lord.
Different, it was other people, there was
Yes.
allegation against them.
But the allegation against.
But you were the direct.
My lord, may kindly to the page 28. 28. And my lord, the FIR was of 11 days.
There is a reason behind that.
And jail superintendent also directed to provide good medical help.
I have not yet for medical care only on the humanitarian. Already I have behind the bar for 85 and I was taken 5 days police custody. Thereafter,
No,
I have
maybe
to-
CDA,
Did it also?
maybe Sarsin is almost on the verge of being submitted also. Third Learned Council, Learned Edition, PP. Having regard to the nature of the allegation. It is felt necessary to erase the PD despite the length of detention of 85 days. Hence, all for CD. This we have to have immediately.
Yes, 1811.
90 days will be over on 9.
So before that we have
1811 or some.
18, along with my postmortem. also.
along with postmortem report.
Yeah.
Highly obliged.
So regular bail, my lord. Petitioner is 20 years of age and is studying his master's, also by profession, private tutor. The informant, 38 years of age, married with 2 children. The FIR is of 25th of October. Would your lordship be kind enough to come to page 14, which is the typed version translated? That's it. Yes, page 14, my lord. This is on 25th of 10, 2025. With due respect, I'd like to inform you that on the last of 7th of March 2025 at 5 a.m., in the absence of my husband, the aforementioned accused promised by making a false promise and giving a job and keeping me in a rented house, forcibly committed physical relations with me. Later, when I wanted to go home, he threatened me in various ways, locked me outside so that I couldn't go home. The aforesaid accused also spent all the money I had on the various pretexts. He forced me to marry him by getting a divorce from my husband, and through mobile, he filed an application for divorce. But as I did not go to court for signatures, I was meted with mental and physical torture. Today, I managed to flee away from the aforesaid rented house and informed about the incident to my husband. Therefore, I pray to investigate. 7th of March, she leaves home, my lord, 5 o'clock in the morning. And from 7th of March till 25th of October, my lord, has not even complained or anything filed against by the husband or the family. She leaves 2 of her children, neither from her own family side. She is apparently been told to be kept as a hostage in Guwahati, the rented house. No complaints, nothing. All of a sudden, she comes back and files this complaint. It's an admitted position that this petitioner was also engaged in teaching her eldest son, her daughter, as a private tutor. So the relationships is already established and there are certain aspects, and I have put it on record, my lord. If your lordship then goes to the forwarding report, my lord, it's at page 18. The grounds of arrest are mentioned, my lord, at the bottom. It says the accused's name FIR. He admitted his guilt and accused of sexual intercourse with him by making a false promise to marry her and give her a job. Sufficient evidence have been found against him regarding his involvement in the case. If he is released under 32(5), and so the every possibility of he may abscond. He's a local resident, my lord. If he is released, so and so he may again be involved in such a crime. And annexure 3, my lord, are the pictures. This doesn't look to be a captive situation at all. The lordships will see the pictures. They are in colored photos, my here. Page 2021. A 38-year-old lady, 2 children.
Yes, PP.
That's it.
Pictures speak louder than words. Is it not?
That's
Atlantic Council for the Petition. PP. This is an application on the allegation against the present petitioner is that he entered into a relationship with the informant by giving her a false promise of marriage and of providing her with a job, and then induced her to elope with him, whereafter they had been living in a rented house in Guwahati. It is also alleged that the petitioner entered into physical relationship with the complainant in course of their relationship. Where the date of occurrence is stated in the FIR is 7/3/2025, and the FIR has been lodged on 25/10/2025. It is submitted on behalf of the petitioner that the informant, who is a 38-year-old lady, voluntarily went away with the petitioner in view of their love relationship. The attention of the court has been drawn to the photographs of the informant and the petitioner annexed to the bail application, wherefrom the relationship appears to be consensual in nature. In the meantime, the petitioner has spent around how many days?
My lord, I've been in 2610.
almost 19.
Almost
19 days.
about
There will
19
be
days behind bars and further custodial detention of the petitioner is not necessary in view of the nature of the allegations and what has been indicated above. Accordingly, the prayer for bail is allowed 20,000 on safety. Petitioner shall cooperate with the investigation.
Extremely grateful.
Satisfaction of the learned Ilaka magistrate. Charge sheeted.
The rejected. I have rejected.
NDPS commercial quantity.
All right, have to see the CD.
A scan copy of TCR.
Can copy of TCL. It is a charge sheeted case. Hence call for the scan copy of the TCR along with the CD.
Regular bail application 108 was arrested on 8th and 20. Thank you.
In 12. CDPP call for on 312. Take. Take 112.
When?
112.
Plus
Is matter pertinent to one Kokana PS. 7/3/2025 euro. It was charged at your. That was in the court of. Was picked up. The charge is not next. Also. There copies are there. On Mary. 14%. I'll come to the FIR. Hospital fine at case 30. Case 30. So type of grievances was raised. The FIR. Case 30. The first one that when I extracted the account under that was legally taken, that is the and it page 27 26 and 27 so and I this was file and there is that was still report was that is the first part of the FIR. The bail application. The second part, some relation to yes. Something is not being changed. Thing file is course of time. Because the FIR itself.
You have any the charge sheet?
Charge sheet is there, your lost. Thank you. All right.
Seems you have extracted a good amount of money.
It was being also deposited, subsequently deposited to
Hmm?
system company. That was deposited and all the information was provided by my friend. That was extract the money, deposit
Deposited where?
to the victim's account. All this is as a whole ownership of those. Next. He extracted money, then he the account of complainant vendor.
After perusal the case diary and court was on trial court rejected the prayer of granting bail.
Yes, and also the order
Lordship,
rejected order is the records with the trial court itself. They have argued before rejected bail, but subsequently, they going to hold any witness. I can guarantee. The liberty is granted, going to do anything. The liberty cannot be misused.
How long? What is the date of arrest?
Date of arrest, 19 September.
I think he has been long enough. Heard Mr. Learned
RP.
Counsel.
RP has it.
Learned Counsel for the petition. LPP decision application method. The brief of the case is that on that the brief of the case is that the informant lady had known the petitioner since September 2023 and they entered into a romantic relationship in course of which the petitioner fraudulently obtained money from the mother of the informant amounting to rupees 669,000. Apparently to get some work of the complainant done. Subsequently, his attitude changed. He started torturing and abusing the informant and also made a false promise to marry her. Is further alleged that he stated in the charge sheet that the petitioner had sexual intercourse with the informant several times by using deceitful means. Sarah, it is submitted on behalf of the petitioner. He had already deposited the money taken from the mother of the informant in the account of the informant. You deposited the money in the account of the informant.
Yes.
Para. It appears that the charge sheet has already been submitted and the petitioner has been in detention since you're in detention since date of arrest
19
September.
September, 19 September.
And has already spent, therefore, has already spent around 55 days in custody. Where considering the length of detention and the fact that the investigation is over, as well as the nature of the allegation, the prayer for bail is allowed. 50,000 to surety.
SDJM work.
Satisfaction of SDJM. Is further submitted that further provided that it is regularly appear in the trial if it commences and shall not try to influence or intimidate the witnesses in any manner. Stands allowed. English and back. It is not.
Simply applied.
Cardiac lordship the page to woman. And for 7 years, my lord, the judge for 2 days 45. If come because my lord is a newly baby born and well, I'm not on married at this time, your lordship already discussed. Page 25.
So this is second application.
Yes,
All right, we have to see the CD then.
only matter for the charge sheet has not been filed to our information. That's the information come with the charge sheet filed.
Learned
Page
TP
45 days.
to obtain instruction whether charge sheet has been submitted or not. In case charge sheet has not been submitted, I have to submit the CD. Only for instruction.
This is one instruction one. Hello, Kitty, my lord.
When?
Next week.
Right. All right.
As per instruction. Then I will do this.
The prayer of Mr. Sun, who?
Assist.
You are?
Assist.
Yes?
Assist. Yes.
Matter is dismissed as withdrawn.
Please. CD may kindly call for your lordship. It's a Ditpur PS. It's a prayer short date.
All right, call for the CD.
38 days in custody. Your lord. Pleasure.
Allowed item 11, 20 are from done.
All right, CD. Item?
11, 20, and
29 lordship, CD received lordship.
29.
20. He received
CD
the
received
same
lordship.
FIR.
Okay.
25.
So we can consider today itself.
Today lordship, along with item number 20,
29 and
50.
50. You're representing all.
No lordship. 29 by another. I am.
So you wait till 29. Maybe we have to wait till 50 for the council to come. Well, since we are taking this up together, all these three matters,
Lordship.
learned councils in appearing in all three matters should be present.
How do I look?
Call up to 29.
Probably. My lord, prior to filing, my lord, bail application filed prior to FIR, because the FIR was lodged on 10th of October. I filed this application, my lord, on 4th of November. Subsequently, the FIR has been, I'm put up the FIR, my lord. Just today, yesterday, my lord, a purely civil dispute, my lord. One sale agreement was executed between the informant and the petitioner number 1, my lord. And the only allegation is that, my lord, the petitioner did not hand over possession of the land to the informant. The allegation. And, my lord, on 20th of October, I was called to the police station by the IO. And I went there after, my lord, executing a PR bond, my lord, I was allowed to go, my lord. And again, after 3 days, my lord, I was again called to police station. I went there, my lord, and my statement was recorded and I was allowed to go, my lord. In the meantime, my lord, petition number 2, my lord, she is my wife, my lord. She is a heart patient. She was admitted in the LCD hospital, but for better treatment, I took her to Bangalore, my lord. On 25th October, I took her to Bangalore. And 2nd of November, my lord, I brought back to Guwahati. What happened in between, my lord? On regular basis, my lord, police went to my house, my lord, arrest me. Then, my lord, I was compelled to file this bail application before this court, my lord, apprehending my arrest. And secondly, my lord, on 10th of November, my lord, since I was, my lord, regularly harassed by police, my lord, so I filed a complaint before the Commissioner of Police. And that, my lord, there is a cross FIR also, that cross FIR has been registered against the prison informant, my lord, but she may kindly there is a cross FIR also, my lord. In my absence, my lord, the police, my lord, facilitated the informant to capture my landed property, my lord, when I could not stay at my house due to, my lord, regular harassment of the police, my lord. The informant, along with some mafia, they entered my premises to capture my landed property, my lord. I lodged an FIR, my lord. That FIR, my lord, initially it was not registered, but after I made a complaint before the Commissioner of Police, that FIR has been registered, my lord. Lordship, this is a cross FIR, my lord, 201 Nunmati PS case. Now, what happened? Lordship may kindly come to the allegation.
Now, what
that
is
has been
the FIR of the in respect of which you have
198.
committed?
198. 198. 30 PS case, first FIR 198. In that
Age?
case, my lord, in my bail application, my lord, the FIR copy was not submitted because at that time FIR was not.
Oh, at that time you were not aware of the.
Not ever. In fact, my lord, the FIR was also not registered. The FIR was subsequently registered. This FIR is dated, my lord, 18th of October. Lordship may kindly come to the FIR in, my lord, 198 30 PS case. 190. This FIR was lodged on 18th of October 2025 and registered on 8th of November, my lord. And I filed this bail application on 4th of November, my lord. And this section, the only section is, my lord, cheating and criminal breach of trust. How is a purely a civil dispute. A civil dispute has been given the color of a criminal offense, and my lord, I was my lord, harassed by the police as well as the government. So for the allegation, my lord, allegation, my lord, Lordship may kindly peruse the, my lord, FIR. So far, here this LAP has been filed by both are husband and wife. At the time, my lord, I was aware whether the FIR was in number 1 or 2. So for the FIR is concerned, my lord, with the FIR for 1 is the accused. So in respect of petition number 2, my lord, her name may be All the bail application shall be considered in respect of petition one matter.
We'd heard learned counsel for the petitioner. At the outset, it is submitted that there is no allegation against the petitioner number 2 in the FIR that was filed subsequent to filing of the instant bail application. Accordingly, the name of Srimati Sayanika Das, petitioner number 2, be back off from the instant bail application, pre-arrest bail application. Referred under section 482 BNS in respect of those renew subsequent to filing of the instant pre-arrest bail application, FIR being FIR was lodged on 7/11/2025 by the government Dilip Kumar Deka on the basis of which Nunmati PS case number 198 of 25 under section 316 within bracket 2 stroke 318 within bracket 4 stroke 351 in bracket 2 stroke 3 within bracket 5 BNS was registered as per the allegation made in the FIR. There was an agreement for sale of land between the informant and the petitioner, pursuant to which an amount of rupees 53 lakhs was paid by the informant out of the total consideration 55 lakhs to the petition, but the petition refused to execute the sale deed, and the informant could learn from reliable sources that the petitioner had taken huge amount of money from different persons for sale of the lot of is of petition written the government
For my statement, it only 5 lakh rupees. It's an
we are saying about the FIR
valid.
to threaten to kill the submitted on behalf. It is the dispute is purely of a civil nature. And only an amount of rupees. How much you have received?
6.5 lakh.
6.5 lakhs has been received by him as advance sale price in respect of the plot of land. So why didn't you execute the sale deed?
So, my lord, Lordship may kindly come to page number 13 of my petition. My lord, herein, actually, he was supposed to pay 10 lakh rupees advance, my lord. But on the day of execution of the agreement, he paid only 5 lakh rupees, the very initial day. So, my lord, this portion was kept blank, the advance amount portion. Lordship may kindly come to page number 13. The amount portion is kept blank, my lord. Then again, my lord, in the money received, Lordship, page 14 also, my lord, page 14, para 2, my lord, that till today the purchaser second party has paid an amount of rupees, my lord, it was kept blank, my lord. Because, my lord, since both are friend, my lord, it was agreed that, my lord, on the day of 10 lakh, on the day of payment of 10 lakh rupees, this amount will, this portion will be filled up, my lord. But what happened? In the original portion, my lord, he filled up, my lord, instead of subsequently, my lord, he paid another 1.5 lakh also, so 6.5 lakh. 6.5 lakh. So instead of 6.5 lakh, he has written the 53 lakh month, and he pressurized me to hand over the land, month. So without full payment, my lord, I cannot hand over the land, my lord. This is the problem, my lord. And my lord, in the money receipt also, my lord, this my lord may come to page number 16, my lord, 16. This is the money receipt, my lord. Here also, my lord, the amount portion was kept blank, my lord. And he, my lord, forged these documents, fill up this gap, my lord, with an amount of 53 lakh, my lord, and he closed this affair, my lord. In fact, still, my lord, he can go to civil court to, and file an illegal performance of contract, my lord. The civil nature. And 2 times, my lord, I was called to police station, and every time I went there, and I was allowed to go on executing a peer bond. And only, my lord, I left Guwahati for treatment of my wife, my lord. The police party came to my house on regular basis. The,
Okay. What is the last line? Since the agreement was for payment of an advance amount of rupees 10 lakhs, the from a pending receipt of the remaining amount, the petitioner was not required to execute the sale deed. Is further submitted that due to such non-payment, the amount column of the agreement for sale was kept blank, comma, which has been annexed as annexure 1 to the instant. There are call for the CD having regard to the proceed submission is provided that the petitioner event of his arrest in connection with the subject case shall be released on interim pre-arrest bail of rupees 50,000 with security or like amount to the satisfaction of the arresting. It is further provided that the petitioner cooperate with the investigation, shall not try to intimidate the witnesses. List again now.
developed.
May I please, your lordship. Lordship, this is an anticipated bail application, my lord. Lordship, find the FIR at least 10 months. What happened in this case, my lord? My vehicle was hired by one Mammon and Samim man. My vehicle was hired by them, my lord. And thereafter, by carrying some American arts and all this vehicle was taken and was, my lord lordship, find the FIR. And while the vehicle was unloading, my lord, some people gathered and called the police. Thereafter, those person fled away. I am not present in this case, so I am no way connected in this case. Lordship will find that, may I read the FIR, my lord? With reference to the subject cited above, I do hereby honor to inform you that on 23/7/25 at about 6 p.m. while I along with my driver friend Amjad Hussain Laskar were coming from Kachar towards Guwahati in my truck bearing registration number so-and-so, loaded with Erica nut, two vehicles, one an Alto bearing registration number so-and-so and a Tata Yodha bearing number so-and-so, which is my vehicle, man, wrongly restrained our truck somewhere between Lanka to Bhalukmari on the highway. Then from the both vehicle, two persons came to us and entered our truck by identifying themselves as police. I have noticed more 5-6 persons in the both vehicles. At first they,
So it's your vehicle.
my lord,
It is your vehicle.
one is my one, the truck is my vehicle. Other one is not my vehicle.
But two vehicles were involved. One of them is yours.
Oh, yes, yes,
Then
yes, ma'am. At,
CD.
my lord, kindly peruse that the FIR was lodged on 23/7, my lord. And the FIR was lodged on 26, my lord, after about 3 days, my lord. If the incident has taken place, why the FIR has been lost after 3 days? And my vehicle was seized after about 2 months, my lord. I have perused the seizure list, my lord. Kindly peruse page 16, my lord. Page 16, that is my vehicle, 24/9/2025, my lord. And when I went to the police station, my lord, for releasing my vehicle, they threatened me not to come in police station. Otherwise, they will arrest me in this. I am no way connected. My vehicle was taken on hire, my lord, that is by one Samim and Mammon, my lord. I have stated in paragraph 4 of my petition, my lord.
The seizure itself took place on 24/9/25 when you are here today.
My lord, my lord.
Seizure took place more than 1.5 months back.
My lord,
You are
my
here today.
vehicle was not releasing, my lord. I have to pay my installments, my lord.
Mhm.
And when I tried to release my vehicle from the police station, they advised me, first I have to take bail.
Thereafter, you waited for 1.5 months to come to the court.
No, my lord, I
Wait-
have
Wait for
filed a
another
petition.
2 weeks then.
Then short date, my lord.
On 26, 27. 27.
Last.
Yes, bill application, my lord. Where is the page 8, my lord? Delegation under section 69 NS. Put the government are employees of Roman Hospital, my. Both are married, my lord. Both are married. His allegation that I promised her to marry, my. I never promised her because she even attended my marriage, my lord. Your lordship will see their family photo, my lord. Page 15, my lord. To my family, my lord. Page 15, my lord. My family, I have a son, my lord. She knows it very well, my lord. And then page 16, my lord, her family, my lord. She also has a son, my lord. She is married, my lord. She even, that is whatever relation we have, it is with full consent, my lord. I never gave any promise or any inducement to her, my lord, because she knows my marital status, my lord. Whatever relation she had, it is with full consent, my lord. She is a major, my lord. She is already married, and both are having children, family, my lord. And I have told my son's birth certificate. I have annexed on page 17, my lord. But both are major, my lord. Why should I give any promise, my lord? Because she knows my marital status, my lord. I also know her marital. We used to visit our families, my lord. There cannot be any kind of promise, my lord, because I am not interested in second marriage, my lord. Because I have family, I am happily with my family, my lord. Your lordship will protect me, my lord, in the interim, my lord.
We can dispose of this.
Lordship can
Yes,
dispose.
my lord.
I'd learned counsel for the petition. Read additional PP. Reason application under the allegation as contained in the FIR is that the petitioner who was working as a nurse, working as a nurse in a hospital, had been in a relationship with the petitioner who is her co-worker, who is her co-worker. They had a physical relationship. It is alleged that after such relationship, upon a promise of marriage from a petitioner, frequently refused to marry her. It appears that both the petitioner and the victim, alleged victim lady, are married persons with children, and both were aware of each other's marital status, and therefore it is therefore, as submitted by learned counsel for the petitioner, it is not believable that the informant would consent to a sexual relationship on the promise of marriage. There having regard to the aforesaid facts and circumstances, the custodial interrogation of the petitioner not deemed to be necessary. Accordingly, the prayer for arrest bail is allowed. Petitioner, in the event of his arrest in connection with the aforesaid case, shall be released pre-arrest bail of rupees 20,000 with 1 year for the satisfaction of the arresting authority. It is further provided that the petitioner cooperate with the investigation. Bail petition stands disposed of.
Close of my lord. Deeply applied.
Matt. Lordship, this is an anticipated bail application. FIR starts at page number 14, Lord. And the relevant page at 19, Lordship. So, long FIR, Lordship. May I submit the gist of the FIR, Lord? What has happened, Lordship? The complainant is involved in coal mine business in the state of Nagaland. And he has been doing business in partnership with some other people from the state of Odisha as well. So, I mean, after having business for a long time, Lordship, in the year 2020, has come in contact with the petitioner, Lord. And they come into an agreement by way of a deed, Lord, to do business along. But what happened in the year 2025, Lordship? One of the partners of the complainant has lodged a complaint against the complainant, Lordship, and he was arrested, Lordship. So, Lordship, while he was arrested, Lordship, and he was in jail, Lordship, it is the allegations that during that particular time, Lordship, the petitioner has misappropriated some amount, Lordship. But what had happened, Lordship, actually, Lordship, while he was in jail, he has come to the knowledge of the petitioner that the complainant is involved in some kind of fraudulent activities, Lordship. And it has also come to the knowledge of the petitioner that one authorization letter has also been issued by the complainant secretly, Lordship, in the name of some other people, Lordship, for, for imparting his duties, Lordship. So, while his suspicious activities has come to the knowledge of the petitioner, Lordship, he has withdrawn himself from the partnership, Lordship, and he has also instituted title suit, Lordship, in the Court of Civil Death Junior Division, Nazira, Lordship. that is annexed at page number 22, Lordship. So, Lordship, after the complainant has been released from jail, he enraged and he started to extort the petitioner to, come in terms with him. But while the petitioner has not complied with him, Lordship, he has instituted that concocted, fabricated FIR, Lordship. Lordship may kindly note that, Lordship, in the page 21. May I draw your Lordship's kind attention at page number 21, Lordship. The last paragraph, Lordship.
Yes.
Lordship, he has alleged that on 6/5/2025 at about 9:30 a.m., I, along with Pranab Kumar Rai and so went to the house of Diganta Chetia and requested him to pay the misappropriate amount from me and my company. Hearing all this, the said Diganta Chetia abused me and other persons by using filthy and unparliamentary languages. And when object, the Diganta Chetia has informed that Samir Patnaik, Nirup Sundar Chaudhary and so misappropriated the said amount and also threatened me that in future, if I came to his house, he shoot me and family. And further, the Diganta Chetia came towards me and my parents who are along with me at the time and with a sharp dao, and having no alternative, we ran away from the house, Diganta Chetia, and due to such reason, we have saved our life from unwanted situation. Lordship, this is the allegations of the alleged occurrence of incident is on 6/5/2025 in the month of May, Lordship, and it has been lodged in the month of Lordship 12/7/2025. After 2 months from the alleged incident, Lordship. So it has completely concocted story, Lordship, and it has complainant has started to give, tried to give criminal color to a civil dispute, Lordship, arisen out of a contractual agreement between the parties, Lordship. So, Lordship, this is the fact of the story, Lordship. Moreover, Lordship, one of the co-accused has already been granted bail, Lordship. That has also been annexed at page number, Lordship may find it 48, Lordship. One of the co-accused, Nirup Sundar Chaudhary, has been released on bail also. So, considering the situations, Lordship may protect me, Lordship, because this is a completely fabricated story narrated by the complainant, Lordship, to harass me, to cover his fraudulent activities, Lordship, and to take revenge against those his partners, business partners, Lordship. And I have become scapegoat out of this, contractual disagreements. The allegation of Lordship 109, and it has been filed after 2 months from the alleged incident. It has shown the clandestine nature of the complainant, Lordship.
Hard learned counsel for the petitioner, also hard learned additional PP. This is an application under so and so. All for the CD. Having regard to the fact that the FIR was lodged long after the alleged occurrences, and the fact that the dispute prima facie appears to be of a civil nature is provided in the interim that the petitioner, in the event of his arrest in connection with the aforesaid case, shall be released on bail of ₹50,000 with security of like amount, the satisfaction of the interim pre-arrest bail. Further provided that the petitioner shall appear before the IO in a period of 7 days. He shall not try to hamper the investigation or tamper with the evidence. Please again on
1512.
Highly obliged.
first line, the hard Mr. to the
Obliged, Lordship.
Hey, please get on. This is nearest bailiff
Yes,
lady. Her husband. First, all is
CD Lordship.
take note. Let's see the
Four.
Wait, please. Petty bail application. Petitioner ran away with informant 5 months. Having said they ran away. Informant lodged their FIR. After lodging of the FIR, the informant's wife went back to the informant. Now they have lodged this FIR under sections 87 and 141, kidnapping and wrongful confinement. Perhaps the section which would be attracted would be 84, the BNS, that is non-cognizable in 84 is, my lord, enticing or taking away or detaining criminal intent married woman. FIR lodged, 13 months.
And had learned counsel to the petitioner, had learned additional PP. Is an application under going so. As per allegation contained in the FIR, the petitioner kidnapped the wife of the informant under wrongful influence and temptation without the knowledge or consent of the informant. Full stop. It is submitted that after lodging of the FIR, the wife of the informant returned to the informant. Para call for the CD. Para having regard to the nature of the allegation, it is provided that some interim prayer is okay. Same condition appear with yes. Please take in.
Deputy.
I'm deeply obliged.
Every. Well, there is the complainant, my lord, the year 2003, my. Actually, my lord, like to case both the prisoner and husband and wife, both are the security. Mental ill and both the treatment is going on the hospital. Marriage immediately, my lord. Her parent taken her back, my lord. There is agreement. There is amicably settled in the parties agreement. After 11 years later, my wife filed under section 125 for the SDGM. The order passed by the standard SDGM, my lord, at page 43, my. There is page 40 onwards. Awarded, my lord, 1,800 rupees.
You are against what now?
So see, he is now not able to
You are against the which order now?
judgment, my lord, page 40, my lord, impugned judgment. Then first one is, my lord, at page 47, my lord.
So what is the illegality in this order?
Yes.
Simply, I can't pay. Is that a ground for
I
revision?
have index, my lord, his mental.
Huh?
Treatment is going on. As mental hospital. Both the lords, mental, wife, husband and wife, both are,
Both are being mentally treated.
both my lord. Both are psychiatric.
Yes, you are appearing for the wife.
Yes.
Yes.
In page.
What is his profession? What does he do?
Yes, Your Lordship.
What does he do? What is his source of income?
Nothing, my lord. Now,
We don't know all that, but we have to go by what the order reflects. And unless you can point out any illegality,
There is
how
no
are you to
legal-
interfere in revision?
lordship, the amicable settlement also there, my lord. Lordship kindly see page 26, my lord. Twenty-two, my lord, 22. Immediately after the marriage, my lord.
When was that agreement?
Kindly page 22, my lord. Next chapter, my lord.
Divorce by deed.
And both his heart signature also there. Rimpi there, my lord. Rimpi the wife, my lord.
Yes, Rimpi Day's wife. What is this?
Vernacular lordship page 24, my lord.
Under what law is a divorce is effected by a deed?
Then, my lord, they are the divorce. Since I am suffering from diabetes as such, I am unable to household works and take care of my husband and his wife. His family members.
It is quite irrelevant. How can a divorce take place on the basis of an agreement without the seal of the court? This is no legal force at all. So she continues to be your wife. What is your what is your medical document?
Lordship kindly see this. Wife medical document, lordship, I have annexed.
Wife, I understand. Her medical document is there that she of some treatment in a mental hospital. All the more reason why you should pay.
Medical document.
What is your plea now? You say you are also in the same category. Where is that?
My lord, kindly see page 51, my lord. 51, 52, and 53, my lord. There is a visiting consultant, consultant transport mental hospital. Second, also, my lord, mental hospital, mental hospital.
51 is a pharmacy.
My lord, 52, my lord, kindly see. You know, sometimes he visited the local doctors.
Oh.
Second, lord, see, he is Parman Yog MD.
Simply visiting a psychiatrist doesn't prove anything. Especially in revision, we can't take cognizance of all this.
52 and 53 are on same date, Your Lordship.
Wife document also I have annexed, my lord.
Nowadays, anybody can visit a psychiatrist.
My lord, wife document also submitted, lordship, page 34, my lord.
A wife document, what will that prove?
Page 34, my lord. TB Regional Institute of Mental Hospital, Tezpur, Pinky Palm.
That is what we are saying. She is under treatment. That is why she needs the money. All the more reason you should pay her. Unless you can point out any illegality in the order itself, we are not here to interfere.
Not able to earn.
Hmm?
Not able to earn, my lord. Jobless, my
We
lord.
don't know.
Lord, I am praying for modifying this order.
Then you submit appropriate application before that court itself, that your circumstances have changed.
1800 is the cannot bear such pound.
Tell us who can survive under 1800s.
But otherwise,
This is not a market. We can't just,
suffering from is my lord double.
we just can't go by the quantum. Arbitrarily, we cannot reduce the quantum.
Maybe converted 900. Divide my.
We are not here to do that. On what basis do we do that?
Considering the illness, my lord.
Not a court of evidence.
At this stage, my lord, in the interim measures.
We are hearing you finally today. Is there?
Perhaps not.
This is not interim. This is for admission. We can dispose it of it by admission. Who has brought it here by order? Let us go through the judgment first.
Yes, no.
You have children also.
My lord.
Hmm?
After this.
And a new wife.
After this
Yes.
settlement, my lord,
Hmm.
again married, my lord.
Yes.
He demanded dowry also.
You are also a resident of Karbi Anglong.
Yes, your lord.
Who are you living with?
I am a resident of Hoja, your lordship.
You are staying with whom?
In with
Yourself or your parents?
Hoja.
This is a judgment of 2016.
My lord.
You have challenged this when?
Pay my lord. Condone my. Yes, my lord. Part time.
Yes, anything to submit?
My number. Kindly. Some amount. But otherwise, it for my lord.
Lordship, 1800 is too less. I cannot.
Not bear this point there. Proceed. Considering his health condition.
All right, we'll see. CAV.
Oblige.
Oblige, you know.
This petition has been laid for consideration of the Honorable Court. Against, my lord, the rejection of the prayer for granting Zimma of the mobile phones, my lord, which were received by the, my lord, IO, time of arrest of the accused. My lord, later on, these accused persons were released on bail, my lord, finding that there was no sufficient materials DD, keep them, my lord, behind bars. But, my lord, these phones, my lord, these were not returned to him. Right, my lord, prayers being made, it was not returned. My lord, there are 4 number of mobile phones seized from 4 accused persons. And my lord, my submission in the earlier round was also that what is required is the data which is stored in the mobile, my lord, for the purpose of investigation, not the phones itself. So, my lord, it would be incumbent on the part of the, my lord, IO to recover whatever data is there and return the phone to them. Otherwise, my lord, just the phones with them and letting it rot and, my lord, decay does not serve any purpose. And under that circumstances, because, my lord, the law has been well laid down, my lord, in the case of the Sundar Bhai Ambalal Desai's case, your lordship favor, my lord, that these are to be promptly returned, my lord. I don't know for what in custody and not returning, my lord. So it appears, my lord, the note.
Any fresh report is there?
Yes, my lord, we have received a report, my lord, that as per the report, my lord, this mobile handset, my lord, has been sent to FSL, my lord. And from FSL, my lord, it has not been mentioned. To receive, my.
Kindly note, my lord, when it was sent, my lord, and when. Because, my lord, it was, my lord, sometime, my lord, in.
It is not in the hands of the IO when it will be received back.
My lord, he can make an endeavor to get it back, my lord. Then kindly see, my lord, when he has sent it. Because the last occasion, my lord, I was told that it was not sent, it was lying with him. That was
My lord,
also
we
after
have received
24
the
months,
report,
my
my
lord.
lord, in this regard, my lord. So as per the report, my lord, I am submitting.
Yes, it is the report.
So, The lucrative suggestion is appearing from a learned friend, my lord. Says that mobile phones are necessary only for the purpose of seeing WhatsApp and Facebook. Let them go and buy another one. Nowadays, prices have also dropped. So
Hmm.
that will serve everybody's purpose, my lord.
Except yours.
Except my.
So what is to be done now? It is with FSL.
My lord, it be taken endeavor to get it back quickly.
Yeah,
my
that
lord.
is made. It says to collect a seeking report. FSL has already been communicated repeatedly, deputing messenger, but it has been informed that the report is not yet ready.
Matter be taken off the- then, my lord.
As per report of, take down. As per report of the IO, these mobile phones are flying with the FSL Kailipara, and it has been informed by FSL that the report is not yet ready. Hence, list the matter after what,
After 2 weeks,
2 weeks. By which time I will submit a fresh report.
I'm the problem.
List again on, give a date.
And this is the page number 2 only. Page number 2 of the petition. And here the petition number 1 and 2 are the own brother. But what is happened in this case, matter? Petition number 1 took amount rupees 7 lakhs. The petition number 2 for the selling of plot of land, my lord. Due to family dispute, my lord, the petition number did not hand over the possession of the land, my lord. For which, my lord, the petition number 2 lost an FIR against the petition number 1, my lord. After filing the charge sheet, my lord, trial is thus started, my lord. In the meantime, my lord, the matter has been settled between the parties, my lord. According to settlement, my lord, the petition number 1 returned the whole amount, my lord, to the petition number 2, my lord. I have annexed the money receipt also an agreement. That is why, my lord, both filed this petition jointly, my lord, for passing the criminal proceeding. Both are, my lord, own brother, my lord. All dispute there, my lord, already settled, my lord. Between
This is joint petition.
joint petition. Both are own brothers, my lord. Already amount only returned to the petition number 2, my lord, by the petition number 1, my lord.
All right, PP will dispose of the,
Joint petition, my lord.
let's save it.
This is regarding my lord,
23 is
death of a boy in the medical college. Listen,
My lord, whatever, my lord, we have sent this.
yes.
My lord, in this case, my lord, earlier, my lord, we received the case diary, my lord, but we have returned the case diary, my lord, for up to date, my lord. Now, my lord, in the meantime, the IO, concerned IO, he has been transferred, my lord. So new IO has joined, my lord. So he has paid for some time, my lord, because postmortem report is yet to collect, my lord. So all
It
the
is submitted
person
that
they are on, my
due
lord,
to
in
change
the-
of IO, the
my lord, only question, my lord, the allegation against them is negligence.
Eh?
Not against, my lord, that here, my lord. Negligence, my lord, because they are the staff, not, my lord, the medical
for
college.
whatever reason it has been called for. It is submitted by Learned additional PP that due to change of IO, the updated CD and postmortem report is not yet available. Praised for further time to submit the same. Accordingly, list the matter again on
512.
5/12. Interim order passed earlier to continue till the next date of testing.
In time, in all the cases.
Like I said, all the item to help.
May it please your lordship, because here in this case, CD was called for. And as per the information, this CD is available.
We have received the case diary, my lord, but without the postmortem report, my
And then
postmortem
71.
report will be required, my lord. We have already talked to the investigating officer, my lord. He has paid for 7 days time, my lord,
to collect the postmortem report and submit before his honor.
My submission, your lordships, as on date 71 days, your lordship, whether is to verify to to what are the materials are there against the petitioners. If there is no any materials, there may be cause of death, maybe to assault or whatever. But the thing is that your lordship, whether the petitioners has been implicated in the case diary or the 161 CRP, supposed also supposed to.
They are the persons, my lord, who were all along, my lord, with the victim, my lord. And allegation is that, my lord, he drank, my lord, and he became unconscious. But in spite of, my lord, taking him to the hospital, my lord, they brought him to his house, my lord. And as per the, my lord, medical report, my lord, there are multiple fracture in his, my lord, head, the skull, my lord. So postmortem report will be necessary.
My lord. This 17, your lordship. The haphazard FIR, your lordship. After recital of the FIR, prima facie, there is no case against the petitioners. What happened that particular day? The petitioners and the deceased, they went to see one of his friends who had expired, residing in a village. So that day after meeting the deceased person, they're returning and it was supposed to be your taking your alcohol and all. And he was in so inebriated that thereafter finding no way out, he was taken to the house of the lordship, the deceased lordship. And thereafter, in the night, he was there all along in the house. Thereafter, seeing his health condition, admitted in the hospital next day. And in the hospital, he has died. There was no any external injury and all. Had there been any external injury that day when he was handed over to the wife of the deceased? So that day, certainly there could be. And 71 days as on date, your lordship. Considering the period of detention. Supposing that there is injury, that injury whether caused by maybe because since he was so intoxicated, lordship, that he might have fallen and got sustained injury.
It was grievous injury on the back of his head.
Yes, your lordship. Because he was so inebriated, your lordship.
Even if he was inebriated and fell down and had a head injury, instead of bringing him home.
No, he was brought to the home, your lordship.
What?
Yes, the deceased was brought to the home.
That is what I am saying.
Yeah.
Do you have any sense or not? A person having grievous injury on his head, is his wife a doctor? You have taken him home instead of taking him to the hospital, unless you have a guilty mind.
Well, he was under the influence.
PM CD received, but PM report is not available. It is submitted that the IO has sought 1 week's time to furnish the CD. The postmortem report, having regard to the nature of the allegations, is considered necessary to peruse the postmortem report. Hence, place the matter again on
The 24/11, my lord, just staying for 10 days. Will retain the case there.
Case diary be retained.
Sorry, correct.
What time?
time.
29. You are appearing for 11 and 50. And you are 29. Yes, what is the matter?
CD received.
Kindly take up even look. I think even look. Two petitioners are there located. They are in custody as of 30 days. Allegation of theft is their lordship. Lordship may kindly find her at page 9.
A complaint was made from lordship that some miscreants broke into complaint shop and stolen away articles of lordship, mobile phone around approximately rupees 4,13,748 rupees and television 4,050 laptop and other items. Total approximate value of the items lordship were stolen 5,18,713. And during the investigation lordship and the tower dam data and area analysis, the accused person Nasiruddin, Mulksan Ali, and Asaf Ali, and Nasiruddin were established that they were at present with the place of occurrence, and both accused were apprehended and examined. During interrogation, they voluntarily confessed their involvement and disclosed that they, along with Ibrahim Ali, Asaf Ali, Nasiruddin Hussain, and Zaherul Ali, which is alias Ziaul Islam, had committed the theft on night of 28/9/25 lordship, and they have sold the items, stolen articles to Toibur Ali and Tafazul Ali, which were in the item number 29 lordship. They are a petitioners on item number. They purchased the stolen articles. And other item number 50 lordship, it's an anticipatory bill. They are along with them. They are still absconding and avoiding arrest.
They are what? Thieves
are-
or purchasers?
They are the main associates.
Main associate.
Main associates. Along with two arrested person, Asiruddin and Muluk Chand. They were arrested, and along with them, these other petitioners who item number 50 were present along with them. lordship. And they are the item number 29, they are the receivers.
How many days? How many days?
38 days.
Too little. Hard learned counsel for the petitioner, so hard learned additional PP. This is an application under so and so. The allegations as per the FIR
The items are required.
is that paragraph 3. Help it. Is submitted by learned counsel that the petitioners have spent 38 days behind custody and items have also been recovered, and hence their prayer for bail may be considered. Para or contra learned PP upon perusal of the CD submits that the petitioners are the main perpetrators of the theft, and their presence at the PO is also confirmed by the tower dump data TUMPATA. And the amount of value of the stolen goods amounts to about how much?
Lordship, total 5,18,713 rupees.
15,000. Considering the incriminating material available in the CD and the gravity of the offense, the prayer for bail stands rejected at this stage.
Lordship may kindly do.
What? No, we have passed the order now. Item other main is
Anticipatory bill. They are the main
50.
associates.
50.
50.
50, they have not named us, lordship. They main person have not named us.
We come to
Kindly
item
see the
item
forwarding report.
29. 29. 29, who is it that?
They are the
Tafazul Ali.
receivers. They purchased the stolen items, articles. From their possession, some articles were recovered.
Same hurdle. Allegation. Same submission. It is submitted by learned PP with original PP with reference to the CD that the present petitioners are the purchasers of the stolen items and the same were recovered from them. The value of the items same DD amounts. Same rejected. Item 50.
It is a co-associate. They have committed a theft lordship along with this item number 11.
Pre-arrest. Pre-arrest bail. Allegation same. Counsel for the petition submits that they are not the named accused. Case and they are ready to cooperate with the investigation. Where on the other hand, learned PP on perusal of the CD submits the present petition are the main perpetrators of the crime along with other co-accused persons, which fact has been revealed during investigation. Where, having regard to the above, the present is not considered to be a fit case for grant of pre-arrest bail. Accordingly, the prayer is rejected and it is missed. Send back the it is. All right.
My lord, the case, my lord, CD was called for, my lord, it was a mistaken of the fact, my lord, affair has been lost. Informant, my lord, he has submitted, my lord, one affidavit be notarized before the authority, my lord, and informed to the police, my lord. Please, instead of that, my lord, 28, my lord, he informed to the police by executing an affidavit. And police, what he did, my lord, on 30th, send the charge sheet, my lord. Cause of action or not even 10 days. Lordship, kindly have a look, my lord. I'm supplying it. The informant, he himself executed an affidavit. And police, my lord, they file a charge sheet, my lord, hearing number 36635 of 20 on 30/10/2025. 25. Thus, immediately 2 days after, my lord, he informed the police, police filed the charge. A very harsh. Considering that, my lord, it was a basically fight between Kuti and the father of the petition. The victim, my lord, the accused, my lord, he was in the nearby place, and they thought he was the owner. Considering that, my lord, lordship can grant the bail. Informant, he himself said. Between Scooty and father of the informant, and other people local by the what happened. That's the owner asked for money. An informant, my lord, should be integrated to the police.
That's all right. You have managed an affidavit, but what you stated before the police that we are required to.
Charge sheet already submitted.
Charge sheet has already submitted. Either lordship can grant me bail or lordship asks me to appear before the trial court. I'll approach.
Already you appear. What is to be done then? You are.
Some observation be given, my lord, or lordship can grant the bail also. Since affidavit taken in.
We are not very.
My lord, investigation, can it be done for
Inclined
10
to-
days, my lord?
How
So
long
there
have
is
you
a
been
no
in jail?
bar, my lord, not even 10 days, my lord.
How long have you been in jail?
I am jail, my lord, right from my lord 1710. Within 13 days, my lord, investigation complete.
17, 28 days.
1710. And 30, I filed the charge.
You should be happy. All right, you appeared there.
Was before trial court also. That he may appear for trial court.
Had
to
done
get
it
some
counsel
observation,
from the
my lord.
petitioner. It is submitted. The charge sheet has already been filed in the case.
Charge
Is
number
all.
can be detected.
Huh?
Charge sheet number can be written.
Yes, sir.
366 of 25,
Right.
dated 30/10/20.
Is submitted that the petitioner shall appear before the learned trial court for bail of having regard to the aforesaid submit provided the instant bail application is disposed of with the observation that the petitioners shall appear before the learned trial court in case any bail application is submitted by them, the same shall be considered in accordance with law. It is hence disposed of accordingly.
May I take
Give
back,
this
my
back.
lord?
We have not received a case there.
But whether the petitioner should suffer because of their failure, I mean, because petitioners are nowhere involved in the alleged offense, my lord. Whereas in a similar, in the same PS case, my lord, for another accused, CD has been received and it was disposed on 10/11/22 in the Sessions Court itself, my lord.
You have that order?
My lord?
You have the order?
Yes, my lord, I have that. I can give it the printout after some time.
The case there may be called for lordship. For that, we try to what is the case there.
My lord, if your lordship have a look at the FIR at page 15, it's a long affair. But my lord may.
Who has been granted bail?
My lord?
Who has been granted bail?
No one has been granted bail, my
Then
lord.
what order is there?
CD was called for. CD has been produced by the police. That is my submission. They
Yes.
were involved.
That
It
is
was,
why the CD is not
it was
here.
their case, my lord.
It was submitted elsewhere.
Next,
But regarding
Ask the
these
lordship.
petitioners, my lord, they were not involved, my lord. That is my submission.
Now let us see what is the allegation first.
Allegation, my lord, will is to find at page 15. It's a long affair. My lord will directly can come to the second paragraph from the below bottom, my lord. That is the main allegation. It is also reported that on or around 25th October 2025, members of the organization held a press conference in Nalbari, deliberately promoting disharmony. During this conference, hostile statements and threats were allegedly issued against the Hindi-speaking population of the Nalbari district. The inflammatory action seems calculated to incite hatred, create fear, and foment social discord, challenging the peaceful coexistence of the community. During the press conference, public threats were issued, ordering the Hindi-speaking community to refrain from observing the Chhath Puja festival. Further provisions were declared against playing Bhojpuri songs, acts prejudicial to the public harmony. Such actions represent a flagrant, non-lawful interference with the community's constitutionally guaranteed religious and cultural rights, constituting a deliberate attempt to intimidate and marginalize a linguistic minority, thus disrupting the unity and integrity of That is the main allegation. On 25th of October, there was a press conference. They made that statements. My lord, regarding this present petitioner, he has more than 5 months before, on 19/5/2025, my lord will please to find at page 20, he has resigned from that organization still. He was not a office bearer, not as a general member also at that time, my lord. At page 20, my lord.
So already around 15-16 days in custody.
Yes, my lord.
Allegations are a sort of
They're demanding an
omnibus type of allegations.
Lordship, what date moving on
My lord, nothing is there, my lord.
on Wednesday, Lordship will try to produce the case and Lordship will consider after the appraisal of the case there.
My lord, if your lordship will look at page 20, he has already resigned on 19/5/2025. And if your lordship will look at the present committee, which was formed on 2nd of September 2025, that is on page 22, his name was not present itself, my lord. So at the press conference, he was not even present. He was neither member there, nor he was present there. Only because they couldn't bring the CD, my lord, the petitioner has to suffer till what the learned PP is praying for till Wednesday.
I pray for short date, Lordship.
See, we are not really interested in the involvement part now, having regard to the nature of the allegations. Even if the CD is produced, it is
My lord had rightly put it that the whole allegations are omnibus.
heard learned counsel for the petition. This is an application. CD called for has not been received. The allegations. There are 3. Learned counsel for the petitioner submits with reference to your resignation annexure page.
My lord, page 20, my lord. Annexure 3.
Reference to annexure 3 submits that the petitioner had long ago resigned from the organization and was no longer a member of the same at the time of the alleged occurrence. On perusal of the FIR and forwarding report, it appears that the allegations are not specific to the petitioner. And in the meantime, the petitioner has spent around 15 days in custody, having regard to the of the allegations. Further detention of the petitioner is warranted accordingly. Prayer for bail is at 50,000 to 0.
My objection may be recorded.
Yes, again, after learned PP on the other hand, prays to produce the CD.
Much obliged, my lord. And item 32 also similar, my lord. He has also resigned from that post, my lord. His resignation is at page 25, my lord.
This is his name?
Pankaj Roshan Dekar. And he is not even office bearer.
Next four, please. For press.
Highly obliged, my lord. Much obliged.
It is.
Was called for. In this case, two persons have been granted bail by the Honorable High Court, one by your lordship and one by learned session judge. I have annexed those documents also. And today he is 47 days behind the bar. On the FIR, my lord, main engaged is Monishi. That day your lordship has seen it. I am producing it, page 16 is the FIR, my lord. Manish Jyoti Das, the main culprit.
What is your name?
My name is Melod Deep
Roy.
Deep Roy.
According to the forwarding report, you are the main mastermind of this
He is
illegal
the
business.
mastermind.
But when on the same footing, other co-accused have been granted bail.
It is there.
It is. Your lord.
Other co-accused have been granted bail.
Where is the order?
I have given on that day to you. One I have annexed my last by High Court. One is yours order, and one is from Session Court.
My order is dated.
By your lordship, I have given on that day.
Here, sir. Yes. This is Harsh Sharma.
Yes.
This is implication by co-accused. That is why he was granted bail.
Yes, sir.
Your case is
And more,
different.
you see how I have been tortured, my lord, that I have also annexed that your lordship peruse it, my lord. There is a
That
report,
part is over.
PGM, my lord.
That part is now over.
That is in page 31. And now they are pressurizing me to withdraw the case, my lord.
You come out of jail, it will be easier for them to pressurize you. So for your own protection, you remain sometime. This Manish Jyoti Das and Deep Roy, they are I think they are the main.
Yes, lordship. Deep Roy is the main lordship, prime accused.
What is the material against him there?
Lordship, on interrogation of the prime accused lordship, admitted that he, along with Kamal Sharma and Harsh Sharma, has delivered the aforesaid vehicle to one Manipur guy at Dimapur. After delivering the agency vehicle to Manipuri guy, took an amount of rupees 3.50 lakh his Bandhan bank account for his wrongful gain, lordship. And one more case has been registered against this prime accused Deep Roy by Dispur PS case number 886/2025 under section 362 to BNS,
They told you.
where he along with co-accused
They were-
has
that's now what started.
illegally deli-
Taking case one after another.
has illegally delivered one more vehicle eco van at Manipur. There is a racket, lordship, and statement of witness are also there, lordship.
Okay, come after some time.
47 days already spent, my lord. Even if I will not be able to come out, my lord. There is another case they have already registered.
So no point.
They will go on giving the.
Where?
My lord, they have illegally demanded lakhs of rupees to me from their own mobile that I have produced as evidence before the line SAGM. That has been also reflected in the order.
Vehicle also not recovered.
Order dated 6/11/25. Para 1, 2, name change. 3, 4. As per the forwarding report, the present petitioner, Deproy, is the mastermind of the illegal business of selling self-drive rental vehicles of Assam in the state of Manipur. Current additional PP Peruzel CD submits that there is sufficient material against the present petition, who is the mastermind of the entire operation, along with another co-accused. And therefore, he does not stand on the same footing as the other co-accused who have been granted bail. Having regard to the above, considering the seriousness of the allegation, the prayer for bail stands rejected at this stage. So,
Episode. The regular bill application, my lord.
Lordship, charge sheet submitted.
The other day is. The lordship that we talking to. Charges that were submitted against the petitioner only under section 51. Section 2 and 65. Your lordship will find it at page 4, my lord. There are 5 cases. The other 4 cases are all CCL. They've been really ill, my lord.
Lordship may call for the record. Record, lordship.
Mhm.
Record is.
So kindly go through the application for search, my lord. Before that, your lordship will kindly come to the FIR, my lord.
You are for this, Rubison.
Only Robinson. FIR is at page 12, my lord. Application. Name.
Just a moment.
The FIR itself, suspect is against the accused is only the suspects. There's no direct allegation against the present person. And after completion of the investigation, they have filed a search sheet only for conspiracy. my lord.
What are the sections involved? Rashid? 61.
61, 2 and 35, my lord. Common intention to criminal conspiracy. Part of this present petitioner.
61 to 64, 35.
These are against
74,
the
75 against Tolendrajit Assam.
Oscar Dongthong Bam and then Tolendrajit Assam. Against these two persons, 61, 64, 74 and 75. But so far Robinson is concerned, Robinson, Alex Wahan Wam and Aumon Naugam, something like that. Against these three persons, only 61 and 3 and 5.
But we have not seen the statements. You were a conspirator in the crime.
That is the allegation, my lord. That is the allegation. In the FIR itself, it reflects that I was also involved.
He was unconscious, but there may have been conscious people around
He has already
who has
clearly written
implicated
that
you.
CS, I was invited to that party. The petitioner, he was also invited to the party. And after the victim, he was a neighbor, my lord. And she has clearly written that after having drinks, food, she went back to her room.
We have read that.
The incident took place in her residence, not in the party where the party took place. They stated that when I woke up in the morning around 8:15, I saw Oscar was on top of me. That was in her residence. Before that, on the fourth line, she has stated after having a couple of drinks, I went inside my room and took my bipolar medicine. Petitioner is a student. Already in custody for months.
Can
Then he could still
Sir,
face the
going to
trial.
the record lordship already charged submitted.
As we the search committee till here and till in case and face the trial. Then he could
See, after perusal of the case diary, another accused who stands on the same footing as you, that has been rejected by the additional session judge.
That
So-
was written in the lower court.
Yes, so without perusing anything, we cannot, what is your difficulty? Wait for a week,
Call for the
wait for a week. Call for. Can copy of TCR along with case diary,
and the medical report.
call for the issue. Registry is directed to issue reminder to the learned code below to furnish the TCR along with the case diary, including the medical report. Please take it on.
Awesome.
But last occasion, up-to-date case diary was called for.
Is up to date.
It is up to date till 8/11.
Now, Lordship kindly see, but page 9 is the FIR.
PM report
PM report received.
is cause of death.
Cause of death, my lord, death was due to asphyxia as a result of antemortem hanging, which was fatal in nature. My lord, here, one thing is there, the wife of the team in use.
He was
He-
arrested and released on bail by the trial.
Let me. He, my lord, stated that, my lord, because he was harassing her during their conjugal life.
Who has been released on bail?
My lord, the
Name,
accused
name,
number 1,
name.
accused number 1, page 9, my lord,
Anjila Khatun.
Anjila Khatun. He is the wife of the deceased. Since my lord, deceased my lord committed suicide, so she was my lord arrested and subsequently released by the trial court.
But that is bail. But in her statement, stated that, my lord, because in her and was subject that particular day when that person.
What is the name of the deceased?
My lord, Nur Jamal.
Charul Islam.
Accused number 1 is the wife of the son of the complainant.
Accused
Isarul
number
Islam,
1
my lord.
is the wife of the Isharul Islam.
Yes. Deceased is
Isharul.
Isarul himself.
Himself.
He committed suicide, the house of the my lord, accused number 1. And accused number 1 is the wife of the deceased Isharul Islam. And others are my lord, brothers and sisters and
So what is the statement you are referring to regarding
My lord,
amendment?
regarding that, my lord, the wife of the victim, and she in her once stated that, my lord, because it was her for several years after this, she went to her mother's home, my lord, for a fateful day. The person,
Take
their
her.
house, my lord, again, that, my lord, Prakak's. Then he, along with her parents, killed and made it like look like a minus as per her.
They will write anything.
And this petitioner number 1 herein is the mother of the third.
All right.
and we're in interim
Otherwise,
protection
after
and
interim,
our
yes,
statement has been recorded.
Go to order dated 19/5/25, 1, 2, 3. It transfers from the CD as submitted by learned additional PP that the accused number 1, who was the wife of the deceased, had left the deceased some time ago due to disturbances in their marriage and went to her parental home. The occurrence took place when the deceased had gone to the parental home of the accused number one. Perusal of the postmortem report reveals the cause of death to be suicidal hanging, suicide by hanging. Also, having regard to the above, the prayer for pre-arrest bail is allowed. Accordingly, order of interim pre-arrest bail dated 19/5/25 hereby and absolute upon the same condition. Petition stands disposed of, sent back the CD.
Development. My this bill is that is just started. My lord, kindly see the page number 40, my lord.
Trial has commenced. Charge sheeted.
Petitioner showing and responding in person. First petitioner has appeared the trial.
Go and appear.
My lord, tomorrow is the date, my lord, for appearing. My lord, page number 40, my lord. There, my lord, total 9 number, my lord. Our share number is 8 number. My name is on Nur Jamal Sheikh, my lord. The petitioner willingly ready the trial. So this is the case of 2009, my lord, and charges submitted in the year 2020. Now it is pending for the appearance. I am ready. My name is Jamal.
Nur Jamal is the name of the deceased.
This is also and yes, my lord. Name is same also and name is same. 2 person is there, same name. Yes, ma'am.
What is the implication of
The allegation is that, my lord, they hired a taxi, my lord.
that part we know? What
Yes.
is the material against?
Material, my lord, but the direct evidence is not there, my lord. Because nobody has seen, my lord.
Yes.
Only, my lord, all details has been recorded, my lord. On the basis of that, call details, my lord, on the basis of the Prime Minister accused person, my lord. His name has been come, not name accused. Name. That's for doubt on name. Definitely, there will be no name accused, my lord. Because in the FIR, my lord, nobody has seen,
So basically, it is called detail.
my lord.
It is CDR record.
CDR record and, my lord, on the basis of co-accused statement. So some of the accused person were arrested, my lord. They have implicated.
It heard learned counsel for the petitioner, learned additional PP. Updated scan copy is otherwise received.
Yes, it is. 10 copy along with the case there.
Scan copy along with CD has been received. The petition learned. Application clearance failed. Then the allegation for the FIR two. The cases of the year 2009, the charge sheet has been submitted only in the year 2023.
28/11/23 success summit.
Give the date of 2018. And during this period, the petitioner could not be taken into custody. Para appears that the petitioner, not a named accused. He has been implicated on the basis of statements of co-accused person and all detailed records. Para having regard to the above, the view that taking the petition to custody at this stage warranted the facts circumstances. Aforesaid facts and circumstances. Accordingly, therefore, 3 years bail is arrest will be released. 3 years bail of 50,000 to security of security. To the provided connection with the case for the petitioners regularly appear in trial. Disposed of it.
Awesome.
Item 39, we even whether he has recorded his statement or not. That is
Appeared earlier, my lord, we have issued notice under 35 appeared, but our statement is recorded.
but short date maybe also could.
Is submitted that updated CD is not available. Is the matter again of concurrence? Interim order passed earlier to continue till the date of this thing. Yes.
Yes, subsequent to the interim order, they appear, but after that, my lord, that cases who saw them, their colleague persons, my lord, they alleged that my this accused person along with another co-accused, threatening them now to my lord, withdraw their estate.
I have a commission. Lordship may peruse the FIR. FIR, there is only one. I don't know what out. I am from a different district, my lord, and the incident happened in another district.
Who?
My lord, my lordship may peruse the FIR, my lord.
Yes, I have perused.
But there is only one witness in the FIR. I have no knowledge regarding the who are the witnesses.
Yes, you thought nobody saw. FIR may mention one witness during investigation, other witnesses may appear.
Milos may can peruse the That was after interim they appeared. That is-
Now let it pass over the CD.
My lord, the matter may account for the day, my lord. My senior will,
All right.
it will come on Monday, my lord. Matter may come on.
I don't know. You're an interim.
I'm on interim. Monday, my matter.
Usual court.
Monday. On 12.
Interim
Then
order.
my lord,
pass-
CD be returned back.
All right.
I'll level on 12.
Return the CD. Produce the next day.
Level.
Uh-huh.
If I may, my lord, I'm appearing on behalf of respondent number 2. I pray for an adjournment of the day.
23.
Yes, ma'am.
You're When?
My lord, anytime, any date next week. As per
Next week we don't know. We have fixed up on. Convenient.
deeply obliged.
They did not receive.
Interim order passed.
They
20. Same fire. Lordship, same FIR file daily. That is fixed on 7/12/27/11. Let me. Also.
they did not receive.
Same order.
Some of information starts has been submitted.
I have to take it.
Okay. Wait. Take the. What do you want now? Appear there.
Next.
Huh?
Next.
ECR. Do you want to appear before the trial court or do you want to have decided?
Record statement already recorded, lordship.
Not received, lordship.
Third time, my lord. Third time may we give. There is no interim.
On 21. 20.
Which station is this?
Hubri, lordship.
Sorry.
The third time. I'll submit. Next.
20.
Vice.
Last lordship CD was called. FIR is at page 15, lordship.
Victim is implicated, my lord. One witness is my lord. Statement has also been recorded, my lord. He is
FIR
no my-
page?
15, lordship.
committed the offense and also, my lord, come to gross.
Yes. Here's material according to
My lord, informant is implicated, my lord. So, my lord, one witnesses, he has also, my lord, stated that, so the accused person running from the house. These are the, my lord, basically the materials collected.
I'd learn it. Yeah. Then it is the house of former lady. Sat beside her bed and touched out. Most because of him. Covered of tied up. Out it. From upon of body. Pattern egg. The result of the squarely it's other sent.
My lord, this case is connected with that analogous supplementary case. And only difference is that, my lord, in my case, the bail was not granted. Same case, same FIR, same person. But same person means that group of person. No? So this is the case there is not a.
No, no, case there is not come, my lord, and IO has paid for some time now to produce the case there.
Well, in my case, the same your lordship permit me to give this order. Be better because otherwise, I may be arrested.
This is in 51.
No, this is 61.
Huh?
No, mine is 51. This order passed in 4.
64. Sumit Deb.
Twelve 11.
IO has paid for some time. Or that maybe produce the case.
since the other case, your lordship, really say that
Don't know, want to see your role.
I'm a bystander, man.
He has been named as the FIR name accused number 1, my
If you minor, that is not a question. That matter, the same offense, same person. If you not, if your lordship goes to my FIR, my lord, the body of the FIR, my name is not. Lordship go to the FIR, my lord.
FIR, my lord, his name is, my lord, accused number 1, my lord. Where the body name is not there, my lord. The accused column, my lord, his name is mentioned as serial number 1.
No, maybe, that's what I'm telling you. The other person in case also, their name is there in that. The counterblast of the FIR which we have lost. Because in that case, my lord, the accused number 1 is the informant. Here the case is informant, and in my FIR, think of the same FIR. That there, my lord. they are
Learned additional PP submit that IO has take some more time to submit is the matter in
On 24, my lord.
the meantime, no person expect.
My lord, other than 24,
Till
my
the
lord,
next.
around 24, I'll be out of, can it be sometime after that? All 26.
28, when, my lord. 8.
The interim may continue, Mike.
Before.
Obliged.
Yeah, please. He raised bail application, my affair was lost, my lord, in 2004, my lord. Case 7, my lord. And 2 persons, my lord, in this case, my lord, was arrested, my lord. And one of them, my lord, Mainul Haq, he, my lord, uttered my name, my lord. So since, my lord, then, my lord, I was not, my lord, called by the police, my lord. Now, my lord, I have been calling, my lord, frequently, and, my lord, my house also has been searched, my lord. No, nothing has been found. So my humble submission is that, my lord, I will cooperate, my lord, the investigation as and when required.
Yes.
So this is a fake currency note case, my lord, and my lord, charge sheet has been submitted in. Have been in.
Then what will you do?
My lord,
When appear?
my lord, record may be called.
It is submitted by learned. The charge sheet has submitted by CS. For the scan. It is with you.
Yes, there is, does, my lord.
Did he be retained?
I love that. I love.
Arise. Sorry. Party. Right. And party. And the agri jacket dead.
Sorry, once again, I was looking at something else. Yes.
The rising case husband was referred and the like a dead.
X is the order. Where is the
Z.
Z? Z is the order. When where is it continues. Okay, this one.
Part of
How many cases? 12. Hmm. So we simply dispose of this in terms of did not.
part of the record.
Had learned counsel for the petitioner and learned counsel for the correspondent. Right order dated 1/9/2025. The Secretary, Guwahati High Court Mediation Center, has communicated that the matter has been settled through mediation and accordingly the report of the mediator dated 26/8/25 has been placed on record, wherein the terms and conditions of the settlement between the parties have been recorded. Accordingly, the instant revision petition is disposed of in terms of the said settlement and upon the conditions contained therein. What do you call this, report or agreement? The report oblique compromise deed. It's separately there. The compromise deed as well as the undertakings submitted by the petitioner and the respondent. Annexed to the said report shall form part of the record. The petition hence disposed of.
Hello.
The original records may be sent back to the file.
Last time it was directed 5% of the total 7 lakhs. My lord, today I am newly appointed my lord order. And he asks time. Actually he's trying to deposit the money, lord, but economically he's very poor, my lord. This small business, my lord, and still 25% equal to 1,78,500, my lord. And possible pay, my lord, complete the amount, my lord. So he asks for 2 months time, my lord, and as per instruction from the owner, his process is going on to sell his parental property in Upper Assam. And presently he is physically and mentally disturbed, my lord. months' time, kind, my lord.
Answered on so many occasions.
But last time, the days are consumed, my lord, by the party.
Hmm?
My lord, 3 times were given, my lord.
Yes.
This is the 4th time that I'm asking on, I'm first time on behalf of the, last time the petitioner was handed over the file, my lord.
A
And
change
he
of the advocate does not mean it is for the first time.
My lord, there is no alternative.
You have
Extracting
not
them.
deposited even a single paisa, have you?
Lord,
You have not deposited anything at all.
my lord, he has not deposited. There is a direction, my lord, here before the turning as first order, my lord. Security 5,000. The copy 5%.
If you can't pay 25%, what will happen to you after, if this is rejected? When you have to pay 7 lakhs.
Lord, kindly time 3 months time. He has the option sell the property, parent property. Last time asked is the man trying my parent will time or I don't is
What is appearing for the you are
I am for the PRS.
Sultana submits that she has been recently engaged as counsel for the petitioner, and it is her action that the petitioner has been trying to sell his landed property in Upper Assam in order to meet the condition of deposit of 25% of the fine amount, and therefore further 3 months time is required to complete the aforesaid transaction. None appears to oppose the aforesaid prayer. Accordingly, 3 months further time is granted to the petition to deposit 25% of the fine amount. Registry of this court. Petitioner is directed to deposit the said amount on before 14/2/2026. Is the matter again on? See, if 14 is a holiday next. Interim order passed earlier shall continue till the next date of.
This is the petition for condemnation of the 14 ND. I'm not sure what has happened here. the petitioner before lordship is an informant law. His son was killed in front of his shop. So, lordship, what he filed a petition, annexure 1, page 12.
Lord, we are appearing for the respondents for the first time. First, wait. 3, 4, 5, 7, we'll file objection against the delay.
Right.
That's why.
Mr. So-and-so learned counsel appears for respondents number
3, 4, 5, and 6.
appearing for respondent number 3. Praise for time to file objection against
That case, lordship,
incident A.
against respondent number 2. What is this? He is representing 3, 4, 5, and 6.
He's in jail. He's in.
That has to start to attendant jail.
Respondent number 2.
He is not granted with bail, my lord. So he's in jail hajat not till.
Which jail?
Kachar.
It is submitted that respondent number 2 is currently lodged in Central Jail, Silchar. Hence, notice be served to the superintendent Central Jail, Silchar, to the respondent number. Please the matter again on.
7. Diplomat.
Here, my lord, lordship will find on past day, my lord, is on 8/10/25. An order was passed that we have to deposit the maintenance amount granted. Here, the interim maintenance was granted on the day of application when the interim application was filed on 8/8/25. You'll also find the main petition of under 125 CRPC was filed on in the year 2023.
Where is the respondent?
No, notice not yet served. That the steps we have taken as is
When?
service is not complete. Notice we have taken yesterday, we have taken step.
Then
On the day of motion, my lord, there is a prayer
he submitted that
for interim.
steps on respondent. The sole respondent has been taken only yesterday. And hence service is not yet complete. Is the matter on.
Right.
May I please your lordship? Petitioner was convicted under section 304 of part 1, lordship, for 10 years, lordship. And here, lordship, this is the first time I have filed. And lordship, he has served more than 5 years, 7 days less, 8 months, lordship. 5 years, 8 months. And this is the first I have filed, lordship. After filing of the appeal, I have never filed this any appeal. Lordship, why I am saying, lordship, this is not a case of acquittal. But at the same time, lordship will also appreciate, lordship, it is also not a case of 304 part 1. At the best, it will be a case of 304 part. Only a glimpse, lordship, page 21, paragraph 23. Paragraph 23, lordship, from the above discussion of evidence, as well as the confessional statement of it is that it accused journal who has assaulted the disposable posting is there. Journal was examined under section 330 of the code of very categorically stated that in the
So you have
Lordship.
admitted.
Lordship,
You have admitted.
this is corroborated at para 38, lordship. Para 38 by PW10 also. Para 38.
So your only hope is reduction of sentence.
That's what it. And already I have served 5 years, 8 months, lordship, out of 10 years. So if Lordship considers DNS ports have been earlier 436A of CRPC also. More than half I have served. Kindly see para 38, page 30, PW 10. Only 2 lines. I won't waste precious time loss. Para 38, page 32. Only 2 lines. 4th line, the evidence of PW 10 depicts that disease.
Page?
Page 32 loss.
Yes. Para?
38,
Yes.
4th line. The evidence of PW 10
Hmm.
depicts that the deceased was a person of at the time. Also, may kindly consider my already life for more than 5 months. If during the trial and all,
Alright.
then it almost years.
Yes, PP is already entitled as per law also.
10 years control.
Half the sentence here and I will pass order.
Much obliged.
Please, your lordship. The secretary bill application. Lordship has already heard the matter regarding the Techno Global University submission. So till now, my lord, 22 applications have closed this honorable court. All 22 have been granted in. I have annexed all the orders. I am a school teacher and I had introduced one of the candidates to one of the agents. From page 15 onwards, I have annexed all the orders. Also, some students submitted certificates for technology, which the police said was fake. Now they have also projected that this is a genuine university.
There are 50 candidates submitted.
Is page 73. More. Check. Order dated 24/9.
Date is lordship 2011. Other matters are fixed on 2011.
I'm deeply obliged. Will appeal for time.
Due to person because senior company.
Already. Learned counsel praised for adjournment round of personal difficulty of senior counsel. Is the matter again. When do you want?
Hello, second.
Hmm?
Second of
From 2nd to 5th, I have some person.
Second week of December.
9th or
11th.
Huh?
11th.
2nd week.
11th. Interim order passed early. I'll continue till then.
Obligement.